Very good. So on 16th February, we already started the FEMA part. Now we are going to go further in the FEMA topic. I think so. Voice is audible and screen is visible. Can somebody comment in the chat box? Voice is audible. Everything is perfect. Then we can start. Okay, fair enough. So what we discussed in the earlier lecture, that in FEMA, before FEMA, there is an act called FERA. First thing. Second thing, in the FEMA Act, FEMA applies to a person who is a person resident in India, right? And the person resident in India, that definition is prescribed in which clause? Section 2, clause V. Right, or we can say 2 clause 5. Okay, now there are certain other definition we already discussed, like for example authorized person, 2C, for example capital account transaction, 2E, for example current account transaction, 2J. These 4 are the important definition as far as FEMA is concerned. Then we gone through the section 3, and section 3 provides like whatever if a person wants to enter any of the transaction, then Udit, good morning. Sairam, good morning. Okay, so if a person wants to enter any transaction, then he can do so with the approval of authorized person, that is prescribed in section 3. Section 4 is basic section. Section 5 deals with the current account transaction. So you need to remember section 5 also, and section 5 deals with current account transaction. In current account transaction, there are 3 schedules, right? And first schedule talks about 7 to 8 items which are specifically prohibited items, like for example lottery winning, for example purchase of lottery tickets, for example call payment for consideration of a call back services, right? These all are payment of dividend in case dividend balancing is applicable. So these all are prohibited transaction. Government of India will not provide you foreign exchange for the payment of these expenses or income side. Now, there are 9 transactions for which if you want to enter such transaction, you need to take the approval of central government. For example, there is a concept called cultural tours. There is a concept called advertisement in foreign print media up to $10,000 that is allowed. There are some exceptions also, right? If you want to provide some prize money sponsorship, something like that, then there is a limit of $1 lakh. Up to that limit, no approval of central government is required. But if you want to withdraw more than this limit amount, then you need to take the approval of central government. Third schedule prescribes 2 kind of transaction. First kind of transaction for individuals only. For individuals only, right? Now, for individuals only, can you please explain the capital expenditure why taken in current account transaction? No, these are capital expenditure. There is no concept of revenue expenditure, capital expenditure. Capital expenditure, for example, in current account transaction, they have taken 4 type of transactions, right? For example, payment of short-term banking services in the ordinary course of business. Whatever we expend in the ordinary course of business, that is the nature of revenue. Second point, what they have mentioned, like interest on loan. So we will consider interest part, not the loan part. Loan will fall under the capital account transaction section 6. And over this loan, there is an interest cost which company needs to bear, a person needs to bear, that will fall under the current account transaction, right? Sairam, I think your doubt is clear now. Okay. So for income on investment or any other, whatever amount they have spent, for example, medical care of parents, spouse, children, or education of children, so that all will fall under the current account transaction. Okay, so in current account transaction, there is a third schedule which provides like For 9 types of payment, an individual can withdraw $2.5 lakh, right? A person can withdraw $2.5 lakh. Up to that limit, he can expend any of the item as prescribed in Schedule 3 without the approval of RBI. Other than approval, other than individual, there are certain points mentioned in the third schedule which prescribed like individual limits for certain time of different transactions. For example, donation, right? For example, rent, you need to pay the broker to the person, right? So that is section 5. Section 6 talk about the capital account transaction. And what are capital account transaction? Capital account transaction are those transactions which alter the assets or liabilities of a person resident in India or a person resident outside India in India, right? So these are the section 6 means deals with the capital account transaction. Under capital account transaction, they have provided specifically approval. They have permissible 2 types of capital account transaction. For example, payment of there is a point mentioned that is called amortization of loan or payment of installment, that is EMI on loan. That is already allowed, right? And if you want to pay any amount for depreciation of direct investment outside India, that is also permitted. But in Schedule 4 capital account transaction, certain field which are prohibited for the purpose of capital account transaction by PROI. And what are those fields? Like for example, a person resident outside India cannot invest in chit fund business, cannot invest in agriculture, plantation activity, Nidhi company. So these all are exempted. These all are excluded from the investment by PROI, right? Now, Section 7 deals with the export of goods and services, right? Section 7 deals with the export of goods and services. So in export of goods and services, they have prescribed the definition of export. What is the meaning of export in relation to goods? If you are taking something from India to a place outside India, that is called export. And what in case of services, provision of services from India to a place outside India, that we can call as a provision or export of services. In the first chart, they have mentioned like exporter needs to take the reasonable steps to realize the foreign exchange and to repatriate the foreign exchange as soon as possible into India. You need to provide the correct particulars. If you can scroll down the first chart of export in goods and services, right, you will find that concept, right? Okay. So these are definition part. This is the definition of PRII. These are the concepts of current account transaction, capital account transaction, and that is export of goods. And correct particular you need to mention. If that is not determined at the time of export, you need to provide an basic criteria of what amount you are going to receive. Rule 4 is important because that talks about the exemption from declaration. An exam point of also rule 4 is important. Rule 4 of section 7, right? You need to submit document within 21 days. There is a 2 types of document is prescribed. First is SDF and second is Softex. Softex will be used in case of software only. Okay, so this is the form EDF and Softex. And there are some documents which is prescribed or the time duration is mentioned. Section 8 deals with the realization and repatriation. That is, whatever amount you can realize, you need to provide that amount. You need to provide that amount as soon as possible. You need to sell that foreign currency to the authorized person, or you can hold such amount as prescribed by Reserve Bank of India. And there is a time prescribed for 60 days and 90 days as the case may be. Section 9 provides the exemption part from realization and repayment in certain cases. Right? So that's all what we discussed, but there is an important definition. This is the most important definition, that is called person resident in India. So person resident in India, if a person you want to prove that such, or if you want to identify that Mr. A is a person resident in India or not, For this, Mr. A needs to fulfill two conditions. First, in the previous year, he should be a resident for minimum 183 days, means more than 182 days, right? For this, this is first part, and second part, if he goes outside India for the three purposes, then that will be treated as a current PROI. Okay, so we are going to start this section 7. Sainam, your doubt I will take later. Okay, example 7, I will make a note of it, and I will after the lecture we can discuss. Okay. Okay, so now we can start the new concept, and new concept is section 10. So can we proceed with section 10? Yes or no? Can we proceed? With section 10? Udit? Can we proceed with section 10, authorized person? You will find these charts. On our portal, ICAI portal, where you can download the charts of 16th February also, 16th February discussion and today discussion also. And these are already downloaded. These are that authorized person concept was covered in 16th Feb notes also, right? Okay, Abhilash. Okay, so we can start. That is concept, right? Authorized person. Section 10 deals with the authorized person. Okay, so definition we already discussed. Now, what is authorized person? Authorized person definition is prescribed in section 2C, and that deals with the 4 points. Authorized person means authorized dealer, money changer, AD, money changer, offshore banking unit, and any other person who is authorized under section 10 to deal in foreign exchange or foreign security. So that is the definition of authorized person, which we already discussed on in our previous lecture. Now, what are the other provisions as prescribed in section 10? So first is duties of authorized person. First point, to comply with the RBI direction. First point is to comply with the RBI direction. This is the duty of authorized person. Why they need to comply the RBI direction? Simple logic, because RBI only is the authority who authorizes you to deal in foreign exchange. So you are binding from the directions of the you are binding by the directions issued by the RBI. So this is point, like to comply with the RBI direction. This is the first point. Second, not to engage any unlawful transaction, right? Authorized person, authorized dealer, money changer, offshore banking unit, they should be prohibited. They should be restricted. They should refrain from doing any unlawful transaction, right? First point is to comply with the RBI direction. Second point, not to engage in any unlawful transaction. Third point, to ensure compliance with the Act rules, right? To ensure compliance with the Act means we are talking for FEMA Act. And rules means whatever rules issued by the central government. Always remember, rules are always issued by the central government only, and regulations are issued by the respective board. For example, there is an act called SEBI. So SEBI is the authority who are going to issue the regulations part. Okay. And what are the duties of authorized person? To report Reserve Bank of India if any contravention takes place. So there are 4 kind of duties as prescribed under section 10 with respect to the authorized person. So first duty is to comply with the RBI direction, basic point. Second is not to engage any unlawful transaction. Third point means you should not convert, means you are converting some foreign currency without reporting to RBI, that is unlawful transaction. To ensure the compliance of the Act or rules, and if there is any contravention, in that case you need to report to the Reserve Bank of India, right? So I think so duties of authorized person, now you can easily remember there are 4 kind of duties of authorized person. Examiner will ask a theory question on the duties of authorized person with other topics of authorized person also of 4 marks, right? So I think so duties of authorized person is clear. Duties of authorized person is clear. Is there any doubt in duties part? Duties of authorized person is clear. Duties of authorized person is clear. Okay. Now move towards the next concept of section 6, section 10, and section 10 talks about the revocation of authorization. Means authorized person, RBI has provided some authorization to any money changer, and what are the cases in which that authorization can be revoked. So revocation of authorization in following cases. First point, RBI can revoke in public interest. RBI can revoke that authorization in public interest. This is the first point, and this is the most basic point. You will find that type of point in SEBI Act 1992 also, public interest. Okay. Second, such authorized person failed to comply with the conditions. Conditions means like whenever RBI is going to authorize any person as an authorized dealer, authorized person, or money changer, offshore banking unit, they will put some conditions over it for this authorization, right? So if a person fails to comply the condition, like for example, they entered they put a condition like there is a disclosure requirement. Disclosure with requirement to single transaction exceeding $5 lakh, right? You need to provide. Then in that case, what type of compliance? For Abhilash, for what type of compliance? Authorized person need to submit a monthly report to the RBI regarding whatever transaction they have entered with respect to conversion of foreign exchange, right? Next is contravene the provision of the act. If they contravene the provision of the act, in both the cases, RBI is going to revoke your authorization. But whenever there is a revocation, there is a reasonable opportunity of being heard. So we can say the principle of natural justice is available, right? So we can say you need to provide principle of natural justice, right? Principle of natural justice you need to provide. So reasonable opportunity of being heard need to be provided by Reserve Bank of India to the authorized person to whom they are going to revoke, to whom they are taking action, or they are going to revoke their authorization, right? So I think so revocation of authorization under section 10, that is also clear. Yet remember one thing, these are the simplest one, but very difficult to remember, but very difficult to recall, right? So there are 4 points prescribed in duties of authorized person and 2 or 3 points prescribed in revocation part. First point, RBI can revoke in public interest. They can revoke if an authorized person failed to comply the conditions or contravene the provision of the act. But whenever they are going to revoke, they need to provide the opportunity of being heard. Now, next is section 11 talks about the power of RBI. Section 11. First is issue of directions for the compliance of the act, rules, etc. Right? RBI, there is a power prescribed to RBI, power given to RBI, like they can provide the instructions for the compliance of act and rules. Right? They can provide the instructions for the compliance of the act and rules. Okay. RBI can call any information as they think that is important. Now, they can impose penalty also if any contravention committed. That penalty you need to remember. When can penalty be levied, right? When they can provide a penalty. When can penalty be levied? There is a space problem. Okay. First point is, if there is any contravention, the directions of if a authorized person fails to comply the directions of Reserve Bank of India, then that contravention happened. In that case, you need to provide what? Penalty. RBI will impose penalty over your authorization over such authorized person. Or if they fails to file the return, then also contravention happened. In that case, there is a penalty part. And penalty is rupees 10,000. If the contravention is continued, 2,000 rupees per day as a further penalty can be imposed, right? So that all is, but before imposing any penalty, again, principle of natural justice will be there. It is called, you need to provide the opportunity of being heard. I think so. Section 10 is clear. Section 10 talks about the three topics. First is duties of authorized person, 4 points. Second is revocation, 3 points. Third is power of RBI, again 3 points with the penalty part also. I think so. What is the penalty? 10,000 plus in case if the default is continued, 2,000 rupees per day is the penalty amount. Further penalty will be levied. I think so. Section 10 is clear. Section 10 is clear. Okay, section 10 is clear. Okay, so move towards the theory part. Section 10, and these are your study material notes, but I rearrange that notes into a proper manner. Okay, so authorized person, section 10 deals with the authorized person. The term authorized person is defined under section 2C, which we already discussed. To mean an authorized dealer, first point, money changer, second point, offshore banking unit, third point, this is a discussion of offshore banking unit, or any other person who is authorized to deal in two things, foreign exchange or foreign securities. Now, what is offshore banking unit? So offshore banking unit is a unit of bank, means branch of a bank, which is located in a SEZ area. An offshore banking unit means a branch of a bank in India located in special economic zone. Right? So offshore banking unit means a branch of a bank in India located in special economic zone. This is the most simplest concept. Although such an offshore banking unit may have a license to operate as an authorized dealer, means RBI will issue license to them, it shall not be regarded as an authorized dealer under the FEMA Act, right? Although RBI issued a license, but then too, they will not be treated as an authorized dealer under the FEMA Act. An offshore banking unit shall not conduct any activity, undertake any transaction with a resident in India, obviously, because whenever there is a FEMA, then they will interact with the person resident outside India. An offshore banking unit may undertake any transaction with any authorized dealer in India on a principal-to-principal basis. Offshore banking units are meant to facilitate units in special economic zone and may undertake transaction in foreign exchange with the unit in a special economic zone to the extent that the latter is eligible to enter or undertake such transactions. Appointment of authorized person. The RBI has the power to appoint an authorized person under section 10. Appointment on application. A person may be authorized by the Reserve Bank of India on an application made to his behalf to deal in foreign exchange or foreign securities. Such an authorized person may function as an authorized dealer, money changer, offshore banking unit, or any other means, whatever they deems fit. Any such authorization made by the RBI shall be in writing and shall be subject to the conditions prescribed in authorization. SEZ is same as income tax. Basically, SEZ as per the SEZ Act 2005. Now, income tax and FEMA, they all procure the provisions from the SEZ Act. Authorized person shall comply with the directions of RBI. They need to comply the directions as prescribed by the RBI. An authorized person must, in all his dealing, whether in a foreign exchange or a foreign security, they need to comply with the general or special directions order of the Reserve Bank of India as they issue time to time. Also, except with the previous permission of Reserve Bank, an authorized person may not engage, right? They are not going to engage without the approval of RBI any transaction involving foreign exchange or foreign security which is not in conformity with the terms of his authorization, means unlawful transaction. Authorized person may ask for declaration information for carrying on any transaction on behalf of any person before commencement of any transaction in foreign exchange on behalf of any person. An authorized person must insist that such person makes a declaration and give whatever information in order to satisfy that transaction is not involved and is not designed to contravene the provision of act, rules, regulations, notification, direction, or order as issued under this. In case of contravention or non-compliance of any requirement, if such person refuses to abide by any requirement or the compliance is not good enough, the authorized person shall refuse in writing to undertake the transaction. And if the authorized person has reason to believe that any such contravention or evasion of contravention is contemplated by the other person, the authorized person shall report the matter that with the Reserve Bank of India. It is a duty imposed on the AP that you need to report that matter to the respective Reserve Bank offices. If any person other than AP means authorized person, who has acquired or purchased foreign exchange for any other purpose mentioned in the declaration made by him to the authorized person and does not use for such purpose, and you are not surrendered that amount to the respective person and use the foreign exchange so acquired or purchased for any other purpose for which it is prohibited. It is not permissible means prohibited. For example, you use the foreign exchange for the purpose of purchase of lottery tickets as prescribed in Schedule 1 of Section 5, that is called current account transaction. So that is prohibited. Such person shall be deemed to have committed the contravention of the provision of the Act. Revocation of authorization, public interest, already we have seen in the charts. The authorized person has failed to comply with the conditions as imposed. The authorized person has contravened any of the provision of the Act, rules, regulation, notification, directions. An authorization shall not be revoked on ground mentioned in 2 and 3 above unless opportunity of being heard is provided, means principle of natural justice will prevail. Okay, RBI power to issue direction. RBI can issue directions, making of payment or desisting, furnishing, or in case of contravention, right, there is a penalty. That penalty you need to remember in case of Section 10. If the examiner asks anything about the authorized person, any short note on the authorized person, necessarily you need to mention that penalty part, and penalty part is simplest part. 10,000 is the penalty amount for the first time, and if that continues for further period, then 2,000 rupees per day till the default continues, right? So this is the penalty part in that case. So that is Section 10 and 11. Now move towards the authorized person second chart that deals with the Section 12 part. Now it is Section 12 provides power to RBI to inspect authorized person, books, papers, documents, places. The RBI can inspect by whom? By any official, and that officer is especially authorized business. They are going to check the business of authorized person for first point, verifying correctness of any statement information furnished to RBI. The AP has submitted some returns part to the RBI. Now RBI wants to verify that return with the actual records present in the business. So what is the what they will do? For Udit, is there any upper limit for penalty? No, that is not prescribed. To obtain any information of authorized person has failed or furnished, right? If RBI called some information, but authorized person failed to furnish that information, in that case, they will authorize, RBI will authorize a specific person or officers of the government to check such information. And securing compliance, what is the objective behind doing it? To make the compliance process easier. Securing compliance with the provision of the Act, rules and regulation. So for these purposes, RBI provide an officer authority to get inspection of these documents. Duty to produce books, furnish information. To produce any officer inspector such books or accounts or other document. Duty to acquire foreign exchange. If a person acquired a foreign exchange for any specified purpose, this is important part. As far as section 12 is concerned, this is important part. So if a person acquired foreign exchange for any specified purpose, but, or we can say, shall be deemed to have committed contravention, means he has not used that purpose. If he does not use for such purpose, then there is a contravention. Suppose, for example, you took an permission from RBI for 1 lakh US dollar for the purpose of medical treatment of your parents, and you have not used for medical purpose, then there is a problem. Or you use that amount, but there is some remaining amount which you failed to surrender to the authorized person. In that case, you need to surrender that amount, remaining amount, with the authorized person, but you failed to surrender that amount, or use that amount for which it is what we can say, that is prohibited, right? Section 5 of Schedule 1 that prescribed under 7 to 8 kind of current account transaction for which foreign exchange is prohibited, and you have used that foreign exchange for that specific purpose. So law has prescribed like contravention will happen, right? So this is a section 12, and section 12 prescribed the power of Reserve Bank of India, that they have a power to inspect the books, records, documents of authorized person. So is there any problem in section 12? Let me know. Is there any problem in section 12? We completed section 10, 11 and 12, and all the three section comprises of authorized person only. So we can say like one short note will be prepared on the authorized person. So is there any doubt in section 10, 11, 12? So is there any doubt in section 10, 11, 12? If you have any doubt, you can ask it out here. With respect to section 10, 11, 12. Okay. So that is section 12 theory part. It shall appear to the Reserve Bank that it is necessary. Right? It shall appear to the Reserve Bank that it is necessary and expedient to cause an inspection of the business of an AP. Then thereupon, it may at any time especially authorize any officer in writing to inspect such business. Right? You can go and inspect the business, or such an inspection may be made for the following purpose. First is correctness. Second is to obtain any information which they failed to submit, or securing compliance of the Act. Every authorized person is duty bound to produce such books, accounts, other document in the custody or power to the officer making the inspection, and to furnish any statement relating to the affairs of such person, company or a firm. In case of a company or firm, it shall be the duty of every officer, director. They need to provide all the required information which the AP has mentioned. And in case of contravention, right, you can read the contravention part. If there is a contravention of penalty, section as prescribed in section 11 deals with by authorized person, any directions by authorized person fail to file any return as directed by RBI, there is a penalty of 10,000, 2,000 rupees per day, which we already discussed in section 11. Section 13. So that is specific to authorized persons, right? And of any provision of the Act, rules, regulation, notification, direction, order issued by the, right, up to 3 times the sum involved if it is quantifiable, right? We will see in the section 13 also. Okay. Okay. So section 14, section 13 prescribes the penalty part, and section 14 deals with the consequences of failure to pay penalty, and this is also important part, right? Now, there is a provision of imprisonment. If any person fails to make the full payment of the penalty as imposed on him, how many days the time period is prescribed? Within 90 days. And 90 days will start from the date of service of notice liable for civil imprisonment, right? If a person fails to pay, the penalty part within 90 days from the date of service of notice, in that case, so law has prescribed like now we will impose some kind of civil imprisonment also. Now, what is the amount of civil imprisonment? Terms of imprisonment. If there is a demand from department, right? If there is a demand raised in the penalty order exceed 1 crore, how much is the amount? You need to remember that point, right? If it is amount is exceed 1 crore, then imprisonment up to 3 years. And in any other case, imprisonment up to 6 months, right? This is the point. So this is the point. Udit, okay. Interest earned on the foreign exchange received. So whatever amount you are, where this amount will you keep in this foreign currency account? So that is called account is RFC or EEFC, right? Exchange earner foreign currency account or resident foreign currency account. So if you have earned any interest, there is no compulsion to use, right? You can use whatever you want. You can just sold out that amount to the authorized person. He will convert that dollars into rupees and you can accordingly use that. Okay, so this is the terms of imprisonment. And what is the terms of imprisonment? If a person fails to pay the penalty amount within 90 days from the service of notice, then there is a concept of civil imprisonment. And in case of civil imprisonment, if the amount or the demand raised is exceed 1 crore rupees, then there is an imprisonment up to 3 years. And this is the quite, we can say, the greater amount, right? And in any other case, imprisonment up to 6 months. And if the defaulter paid that amount, then accordingly we need to release that person also, right? So this is section 14 part. Okay. So now there is a penalty up to 3 times. Okay. Section 14. If failure to pay the penalty as above, where the demand is an amount exceeding 1 crore up to 3 years, in any other case up to 6 months, right? So that is the penalty part. Section number is 14. Section 14 is clear. What is the case when this penalty will be levied up to, what is the case of civil imprisonment? Section 14 is clear or not? Section 14 is clear or not? Section 14 talks about the failure of penalty and what will be the consequences over the failure, right? So section 14 is clear or not? Kindly comment in the chat box. Section 14 is clear? Clear. Okay. Okay, so penalty amount, the person, whatever penalty is imposed on you, that penalty amount you need to pay within 90 days. If a person fails to pay the penalty amount, then that attract the civil imprisonment. And what is the civil? How much is the civil imprisonment? So law has prescribed if the demand or the amount raised in the notice exceeds 1 crore, then there is an imprisonment up to 3 years. In any other case, 6 months. Okay. Okay. Now, there is a concept of 16 section. Now we are going to deal with the adjudication part. Adjudication means appeal part, provision part, right? In case of confirmation, you can appeal to respective authority. RBI imposes any penalty. In that case, you can make an appeal to the authorities. Okay. So we are going to proceed towards the section 16 part. Section 11, 12, 13, 14, 15, I think so that all section is clear. Adjudication part. Okay, meaning. Now, what is the meaning of adjudication? Adjudication means somebody have committed a contravention and you are going to check that contravention part. It is a process. So, adjudication is a process by which a contravention of any provision, any act, any rules, any regulation, or any notification dealt by the appropriate adjudicating authority. Right? And for this purpose of adjudication, central government has a power to appoint an adjudication purpose. What is the purpose? To hold the inquiry for the contravention of this act, rules, notification, each and everything, right? Prescribed as per the act and rules. So, adjudication section 16. Now, what is the purpose of adjudication? So, law has prescribed central government has a power to appoint any person as a adjudicating authority, and that why we created that authority for the purpose of inquiry. Inquiry with respect to what? Confirmation of provision, act, rules, notification, etc. This is the important point. Duties of authorized adjudicating authority. They need to dispose the complaint, right? It will not like happen like तारीख पे तारीख and all तारीख पे तारीख सिर्फ मिलती है तारीख पे तारीख. That is not the case. So law has prescribed there is a time period, and that time period prescribed on the authority part who are going to resolve that issue. Within 1 year from the date of receipt, if you fail to dispose of that application, you need to specify the reason. What is the logic? What is the logic for such failure? Again, if you are going to dispose any complaint before providing the opportunity of being heard, right? You need to provide opportunity of being heard, right? So this is the important concept with respect to section 16 part. Now, read further. Penalties provided for under FEMA for contravention of provision of the act. Now, this is important. When this penalty is levied, if any person contravenes the provision, rules, regulations, order under this act, or any condition subject to which authorization is issued, means we are talking for AP part, authorized person part, authorized dealer, money changer, offshore banking units part. Yes, means the person contravene any provision of act, rules, regulations. Then what is the amount of penalty? Now this is most important. Amount of contravention identified. If you identified what is the amount of contravention, yes, then penalty can be up to 3 times the sum involved. And if you fails to identify, up to 2 lakh may be levied, right? I think so that is clear. And in case of continuing one, 5,000 rupees per day. Amount of penalty is clear. What is the penalty? If the amount of contravention is identified, suppose for example, you contravene any amount and that amount is 6 lakh rupees. So what is the penalty? 3 times of that contravened amount, means you need to pay 18 lakh as a penalty amount. Okay, and if it is not identified in this case, 2 lakh may be imposed. And in case of continuing failure, 5,000 rupees per day is the penalty amount on which you on the person they can be imposed, the person who committed the contravention. Now, what are the other consequences of contravention? This is the penalty part. The authorized authority may issue following directions also. First is confiscation of currency. Whatever currency you are holding, we will confiscate. जब्त कर लेंगे हम वो currency आपकी. If any provision of the act is contravenes or directions देंगे, right, relating to the foreign exchange holding, you need to repatriate that amount in India and retain outside India as per the directions issued by the authority, right? So this is the point of contravention with respect to penalty part. And if you can check, see this one, right? If any person contravene the provision of act, rules, regulation, etc., then if the amount is identified, then there is a penalty up to 3 times. This is mentioned. And if it is not quantifiable, then there is a penalty of 2 lakh rupees, or in case of failure, 5,000 rupees per day. There is a penalty part. Okay. And 13 what deals with the acquisition of foreign exchange, foreign securities, immovable property, which is situated outside India. Then there is a penalty of up to 3 times if the sum involved. Confiscate कर लेंगे हम आपकी प्रॉपर्टी को, और imprisonment है up to 5 years तक with fine. Okay, I think so. Now that is clear. So this is clear. Penalty part, penalty provided under the FEMA for contravention along with section 16. This is clear, or is there any doubt? This is clear, or is there any doubt? Section 14, section 16 penalty part is clear or not? Or if you can recall the adjudication part, that is the most important concept, so that we can move towards the appeal part. Okay. Provision in respect of enforcement of adjudicating authority. So this is the theoretical part or procedure part. This is the procedure part. Okay. So provision in respect of enforcement of the adjudicating authority section, which is section 14 and 16. Central government authorized person. Central government will authorize a person made a complaint in writing. Then only adjudicating authority will start proceeding. Means there is no power as prescribed to adjudicating authority suo motu basis. Now, what is the meaning of suo motu? What is the meaning of suo motu? What is the meaning of suo motu? This paragraph clearly talks about like when the adjudicating authority will start the acting on that complaint. If any complaint is made by any person, and for to person whom central government will authorize any person, that person will make a complaint to adjudicating authority, right? So there is no power provided to adjudicating authority on a suo motu basis. I think so. That is clear. I think so. That is own. Yes, Priya, correct. So it's own basis, right? Apni ichha se. Okay. Issue of SCN. SCN means show cause notice. For determining whether the contravention made or not, whether the contravention happened or not, authorized authority means adjudicating authority send karegi, bhejegi. What they will send? Show cause notice. And in the show cause notice, they will ask in such a manner why the inquiry should not be held against him. Plus, we will explain what contravention you already committed. That person needs to reply in 10 days. Matlab, it means like government means adjudicating authority will issue a show cause notice. They will issue a show cause notice, and we will in the show cause notice we will mention why we are not going to impose penalty on you because of this contravention. We will explain the contravention part, and the other part needs to reply within 10 days. The 10 days they will ask in the MCQ part also. Okay. Now, authorized authority means adjudicating authority they will issue a notice, fix for the hearing purpose, they will fix date, time for hearing. Accused person may appear himself or a lawyer or a CA, date fixed for the authorized authority, explain to the accused person if any contravention committed by him. Authorized authority gives an opportunity of being heard for the purpose of imposing any penalty, right? Opportunity of being heard provided, you need to provide the opportunity of being heard before imposing any penalty on such person. While holding inquiry, adjudicating authority will have the same power as the civil court possesses, right? This is the most. Civil court means as per the CPC 1908, and the person fails to appear, authorized authority will give ex parte decision. Now, what is the meaning of ex parte decision? 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 What is the meaning of ex parte decision, right? Suo motu is on its own. And ex parte decision means in favor of other party. It means, Udit, okay. So in favor of other party on the default of other means Mr. A and B. There is a dispute arises between Mr. A and B, and if A fails to appear in any proceeding, then court will grant decision in favor of B without listening to A point. That is called court has provided ex parte decision, right? And it's ex parte, PARTE. It's not TY. Okay. Adjudicating authority will dispose that complaint within 1 year. If fails to dispose, then they need to record the reasons behind such failure. Okay. So that is section 14 and 16 procedure part, like what you will do when you will issue show cause notice and all. Enforcement, second part. If you issue any order which is provided for penalty, after considering the evidence produced before the AA means adjudicating authority, provided that committed the contravention, impose such penalty, every order must be dated, signed by the authorized authority. They need to sign that order also, and copy of the order supplied to free of cost. You are not supposed to charge 10 rupees per page or something like that. You need to provide the free of cost copy. And detention of defaulter on conclusion of inquiry if the person finds defaulting person. Upon the conclusion of inquiry, authorized authority may make an order for the detention of the defaulter. Adjudicating authority leave the defendant in the custody of the officer not exceeding 15 days, so that they will ask whatever they want to ask, and release him. We will release that person on furnishing the security part. For the satisfaction of AA. AA means adjudicating authority. So I think so section 14 and 16 procedure part, that part is clear. That part is clear. Enforcement part is clear. Enforcement part is clear. Enforcement part is clear. So you all are getting the FEMA via charts or not? One comment required from everyone. Whether you are getting this FEMA charts or not. Whether these are beneficial for studies or not. Kindly provide your comment. Section 14 and 16 procedure part is complete or not? Okay, Priya. Okay. Okay, so this is the section 14 and 16 adjudication part. An adjudicating authority adjudging any contravention as committed in section 13 may, if it thinks fit, in addition to the penalty which they may impose on the contravention, direct that any currency, security, and either money, property in respect of which the contravention has been taken place, that amount needs to be confiscated to the central government, and further direct that the foreign exchange holding, if any, if the person is holding any foreign exchange and it is not possible to realize and repatriate into India, then authorized person will issue a direction that you can hold that amount with your authority for our benefit, right? Okay, Geeta, thank you. Udit bhai, thank you. Okay, charts are really beneficial for the purpose of recalling the provision, right? Further direct that the foreign exchange holding, if any of the person committing the contravention or any part thereof, shall be brought back into India and shall be retained outside India in accordance with the direction issued by the authority. Explanation: for the purpose of this section, property in respect of which contravention has taken place shall include deposit in a bank account, whether the said property is converted into deposits. Okay. Indian currency, where the said property is converted into that currency, or any other property. So whatever amount you are holding in which currency, you need to keep that amount for our benefit, for government benefit, right? Enforcement of order of AA. AA means adjudicating authority, section 14. If a person fails to make the full payment of the penalty imposed on him within 90 days, then in that case, there is an attraction of civil imprisonment. From the date on which notice for payment of such penalty is served on him, he shall be liable to civil imprisonment under this section, right? Order of arrest and detention of civil imprisonment. No order for the arrest and detention in civil prison of a defaulter shall be made unless the adjudicating authority has issued, served a notice upon the defaulter, calling upon him to appear before him on the date specified in the notice, and to show cause why he should not be committed to civil prison, right? आपको जेल में क्यों न डाल दिया जाए? Unless the adjudicating authority for reasons in writing to be satisfied. That the defaulter, where the object and effect of obstructing the recovery of the penalty, has after the issue of notice by the AA dishonestly transferred, concealed, or removed any part of this property, or that the defaulter has or has had, since the issuing of notice by the AA, that the means to pay the arrear on such substantial part thereof, and refuses or neglect, or has refused, neglected to the same. Issue of warrant for the arrest of defaulter, right? After the inquiry, there is an arrest provision also. A warrant for the warrant. Now, what is the meaning of warrant? Warrant means right. We are listening the word dividend warrant. What is dividend warrant? Means you have provided some right to receive the dividend amount by showing that warrant. So warrant is a right. A warrant for the arrest of the defaulter may be issued by the AA if the AA is satisfied by affidavit, otherwise that with the object of effecting or delaying the execution of the certificate, the defaulter is likely to abscond. So in that case, means वो भाग जाएगा, right? or leave the local limits of the jurisdiction of the adjudicating authority. In case of absence pursuant to the notice served, where appearance is not made pursuant to the notice issued or served, the adjudicating authority may issue a warrant for the arrest of the defaulter. Every other person in pursuance of the warrant of arrest shall be brought before the adjudicating authority. Remember, there is a provision in the CPC, like to whom you are going to arrest, you need to present that person within 24 hours to the nearest magistrate. This is the basic provision, right? Provided that if the defaulter pays the amount, we will release. Default by HUF, the karta thereof shall be deemed to be the defaulter by default. Whether defaulter appears before the AA pursuant to the notice, the adjudicating authority shall give the defaulter opportunity of being heard, right? Sunwai ka ek mauka. In case of pending of any inquiry, the adjudicating authority may, in its discretion, order the defaulter to be detained in the custody of such officer as the AA may thinks fit, or release him on him furnishing the security to the satisfaction of adjudicating authority. Upon the conclusion of the inquiry, the adjudicating authority may make an order for the detention of defaulter in the civil prison, and shall in that event cause him to be arrested if he is not under arrest. Upon satisfaction of arrear means he paid that amount. Order of release, okay. Every person detained in the civil prison is execution of certificate may be so detained, where the certificate is for the demand of an amount exceeding 1 crore up to 3 years, or in any other case that amount is, if that amount below, if the demand raised is less than 1 crore, then in that case there is an imprisonment up to 6 months. Or defaulter liable to payment of arrears. A defaulter released from the detention under this section shall not merely by reason of release. Okay, so if the person is released, it is not necessary that he is not supposed to pay anything. He need to pay that amount also. Execution of detention amount. Okay. Now, the power to recovery arrear of penalty. The adjudicating authority may be by in writing authorize any officer of enforcement not below the rank of assistant director to recover any arrear of penalty from any person who fails to make the payment as per contravention committed under section 13 within 90 days. Okay. Okay. These are the provisions, right? Okay. Now this is most important, and this is the appeal part, right? So there is a appeal authorities, right? Now we are going to see the appellate authority. First is special director appeals, and second is appellate tribunal, right? So we are going to see the two types of appellate authority. So can we start the appeal provision? First chart, second chart, and third chart, appeal to High Court, right? Okay, so there are three charts of appeal for different appeals. So can we start the appeal part? Can we start the appeal part? Section 13, section 14, you need to remember the penalty part. That person needs to pay within 90 days. If he fails to pay, then that will attract the provision of civil imprisonment. And what is the civil imprisonment? So law has clearly specified if the demand raised is up to 1 crore rupees, in that case, there is a civil imprisonment of 3 years, up to 3 years. And if it is less than 1 crore, then there are up to of 6 months. Okay. So now we are going to start the appeal part. Appeal with respect to two authority. First is special director appeal, and second is appellate tribunal. So can we start the appellate part? Udit, okay. Okay. Now, first appellate authority is special director appeals. And that is very simple also, right? Okay, let's start. Special Director Appeals. The central government shall appoint one or more Special Director Appeals to hear the appeal against the order of authorized authority, means adjudicating authority. You can write here also, right? Adjudicating authority, and it is the duty of cast on the central government by the act that they need to specify the jurisdiction of that authority, right? So first point is, who is authorized to appoint the Special Director Appeals? Central government is authorized to appoint the Special Director Appeals. Now, what is the purpose? Like they will listen all the cases as against by the adjudicating by the decisions of adjudicating authority. Now, any person is aggrieved. Aggrieved means पीड़ित. Any person aggrieved by an means not satisfied by an order made by the adjudicating authority, that person can prefer an appeal to the Special Director Appeals. When can appeal be filed? If the adjudicating authority is acting as an assistant Directorate of Enforcement or deputy Directorate of Enforcement, in that case you can apply to the Special Director Appeals. Means, now listen carefully, it means if a person is acting, or we can say if the adjudicating authority is acting okay. Now there is a concept, right? There is a one concept, like this is assistant director and deputy. Now listen one thing. If a adjudicating authority is acting as a assistant directorate of enforcement or deputy directorate of enforcement, and suppose from their decision Mr. A is not satisfied, then Mr. A will prefer an appeal to Special Director Appeals. Important cheese. One more important thing. And if adjudicating authority is acting other than this, means he is not acting assistant directorate of enforcement or deputy directorate of enforcement, means adjudicating authority is acting over this designation. In that case, law has clearly specified. What? Law has clearly specified what? You can directly make an appeal to Appellate Tribunal, means second authority. Now listen carefully. I think so that diagram is clear, right? Let's start again. If the adjudicating authority is providing its decision in the capacity of assistant directorate of enforcement or deputy director, if the adjudicating authority is providing their decision against any person in the capacity as an assistant directorate of enforcement or deputy directorate of enforcement, if this is yes, then you can make an appeal to SD. SD means Special Director Appeals. If this is no, means the adjudicating authority is providing its decision other than these two designations, means higher of these designation, then you can directly then you can make directly appeal to Appellate Tribunal. Okay, now this thing clear. One more thing. Last thing is, and if somebody is again dissatisfied from the decision of Special Director Appeals, then he can again move to Appellate Tribunal. So you can say Appellate Tribunal can hear two types of appeal. One, as referred from the decision of Special Director Appeals or by the order of adjudicating authority, who is not acting in the capacity of Assistant Directorate of Enforcement or Deputy Directorate of Enforcement. One more thing. For this, we can say that this is in that case, this is a revisionary jurisdiction. And this is the original jurisdiction. Original means first time. He is listening first time. That is called original jurisdiction. And this is called revisionary jurisdiction. And if a person is not satisfied from 80, he can make an appeal to High Court. Then there is a concept called Supreme Court. Right? So these all are 4 authorities. I think so. This chart is clear. Who will go to whom, right? That is clear. That is clear. Clear or not? It's clear, right? That is clear or not? Kindly comment. Because that will summarize your whole 4 authorities appeal part, right? That is clear or not? If a person is aggrieved by the decision of adjudicating authority and adjudicating authority provided decision in the capacity of Assistant Directorate of Enforcement, Deputy Directorate of Enforcement, then such person can make an appeal to Special Director Appeals, or if the person acting, if the adjudicating authority provided its decision other than these 2 designation, means we are talking for this line, then in that case, such person directly make an appeal to Appellate Tribunal, and for that particular matter, Appellate Tribunal enjoys the original jurisdiction. And for rest of the matter, like from appeal this to this, in that case, he is enjoying the revisionary jurisdiction. And if any person is still disagree with the decision of Appellate Tribunal, then he can go to High Court, and then again he can go to Supreme Court. And if he is not agree with the Supreme Court also, then he cannot go anywhere. Then आप घर जाओ, simple logic है. आपके पास अब कोई अथॉरिटी नहीं रह गई, राइट? ओके, आई थिंक सो दैट इज क्लियर. Then we will go by the charts part or theory part. I think so that concept is clear. Kindly comment in the chat box that concept is clear or not. That concept is clear or not? Okay, clear. So we will go by charts part. Now you can just fix that image in your mind. You can clear all the 3 charts of appeal part. Okay. Now listen. When can appeal be filed? If the adjudicating authority is acting as an Assistant Directorate of Enforcement. Okay. Order of Special Director Appeals. Special Director Appeals may pass such order, may confirm, set aside. You need to provide opportunity of being heard and send a copy of every order to the party. Udit, don't worry, we will solve your queries also, right? With respect to question bank. Request you to please look up once. The appeal shall be filed within 45 days. Now you need to file that appeal from the date of order of adjudicating authority. If sufficient cause is shown, a special director can extend the time. Means that appeal you need to file within 45 days. That is a time of 45 days. Okay. And no time limit to disposal. There is no time prescribed for disposal part. Now, appeal with the Appellate Tribunal. Okay, before moving towards the Appellate Tribunal, first we will complete this part. Okay. Appointment of adjudicating authority. Okay, that is clear. Okay. Okay. Appeal to Special Director Appeals. Okay, central government shall by notification appoint one or more Special Director Appeals to hear appeal against the order of AA. AA means adjudicating authority under this section and shall specify in the said notification the matter and the places in relation to which the special director appeals may exercise jurisdiction. Any person aggrieved by an order made by the adjudicating authority, being a assistant directorate of enforcement or deputy directorate of enforcement, may prefer an appeal of the special director appeals. Okay, you can prefer an appeal to SD within 45 days, and every appeal shall be filed within 45 days from the date on which a copy of the order made by the adjudicating authority is received by the aggrieved person. The special director appeals may entertain an appeal after the expiry of said period of 45 days if it is satisfied this person is prevented by a sufficient reason for not filing that appeal. Okay, so this is the concept. Okay, FEMA charts. Now, second is appeal with the Appellate Tribunal, and this is the second Appellate Tribunal, section 90. Establishment. Again, there is a central government. The central government shall appoint an Appellate Tribunal to hear appeal against the order of first and second, right? Authorized authority means adjudicating authority, Who can prefer an appeal? Central government, any person authorized may prefer an appeal to 80. 80 stands for Appellate Tribunal. Right of legal assistance. The application may either appeal, take the assistance of the legal practitioner or a CA. The Appellate Tribunal is the second Appellate Tribunal, and they have both the jurisdiction, original jurisdiction and revisionary jurisdiction. Original jurisdiction means first time आपके सामने appeal आई है, that is called original jurisdiction. For that particular matter, you are enjoying. You are enjoying means you need to listen that matter firstly. That it was not presented before any other authority before this presentation, right? And revisionary means इसके पहले और कोई भी सुन चुका है. Deposit of penalty. While filing an appeal, penalty of the deposit with the central government, however, 80 may dispense with such requirement. Order of 80 can order as it thinks fit, opportunity of being heard, copy of order made to the, and appeal disposal is 180 days from the date of filing appeal. If you are not, if you have not failed to dispose of the application, you need to provide the reasons part. Okay, so that is section 19. Okay, so that is section 18 and 19, appeal to Appellate Tribunal. Okay, so the Appellate Tribunal constituted under the Smugglers and Foreign Exchange Manipulators Forfeiture of Property Act 1976. SAFMA shall be appellate authority for the purpose of this act, and the said Appellate Tribunal shall exercise the jurisdiction power authority as confined in section 18. The central government or any person aggrieved by the order of AA or other than those referred in 17.1 or the special director appeals may prefer an appeal to 80. Every appeal should be made within 45 days. 19.2, 19.1. Where any appeal could not be disposed of within a period of 180 days, you need to provide the reasons why you failed to dispose of that application. Next is, I think so, special director appeals and adjudicating authority and 80 is clear. I think so, both the topic is clear. Both the topic is clear. Both the topic is clear. Okay. Now, appeal to High Court. This is the third authority we can say. The appeal to High Court lies only very few cases. The decision or order appeal against have been passed by the 80. Means if you are not satisfied with the 80, you can prefer an appeal to High Court. or the appeal is filed on a question of law, means question of fact is final. High Court will not entertain appeal on the question of fact. Question of law means if there is some mistake in the law, if there is some interpretation issue, or there is a retrospective effect in the law, that can be considered as a question of law. Time for appeal within 60 days from the date of communication of AT order. They can sufficient reason if it is shown, then they will provide 60 further days. Who can file the appeal? Appeal by central government, appeal by the accused. An appeal to Supreme Court. Under FEMA, no provision for appeal to Supreme Court from the order of High Court is provided. Under the FEMA, there is no provision that is prescribed for appeal to Supreme Court, right? But Article 136(1), a person can apply to Supreme Court. This deals with the Constitution. Constitution of India, संविधान का आर्टिकल 136 है that a person can apply to Supreme Court. Okay, appeal to High Court, section is 35. Any person aggrieved by any decision or order of AT may file an appeal to High Court within 60 days. 60 days start from the decision of the AT. Question of law, example of question of law means if there is an interpretation issue in the law, that will involve a question of law. If there is a retrospective amendment in the law, that will involve the question of law. High Court can entertain your appeal. If there is a suppose for example mistake in the law, then this is the, suppose you are providing new kind of evidence, that is question of fact, and that is not permitted for appeal before the High Court. Okay. Udit, I think so your doubt is clear. From the date of communication of the decision or order of the AT on any question of law arising of such order, provided that the High Court may, if it is satisfied with the appellate was presented by sufficient cause, then they will provide 60 further days. Explanation in this section, High Court means the High Court within the jurisdiction of which the aggrieved party ordinarily resides or carries on business, profession, or works for gain, means they are holding their business. And where the central government is the aggrieved party, the High Court within the jurisdiction of which the respondent, or in a case where there are more than one respondent, any of the respondent ordinarily resides or carrying on business or personally work for gain, right? So that all is penalty part, procedure part, appeals part. I think so that is clear. I think so that is clear. Appeal to Special Director Appeals, appeal to Appellate Tribunal, High Court, Supreme Court, that all appeals, I think so that is clear. Appeal to Supreme Court is not prescribed under the FEMA Act 1999, that we can refer to Constitution of India, Article 136(1). I think so till that time that it is clear. Till that time it is clear. I think so that is clear. Okay, perfect. Okay, so we will take it's 8:25 in the clock, so we will take a break of 10 minutes. By 8:35 we can start the little provision, then we can move towards the import of goods and services and ODI concept, right? Okay, so we need to remember that 4 to 5 sections over this, and with this then we will come to import of goods and services concept. Okay, fine. So we will take a break of 10 minutes and we will resume after 10 minutes. So break is over and we can start now. So voice, again, voice, audio, video, everything is perfect. First chart and second is compounding offenses. Okay. Okay. So can we start now? Yes or no? So can we start now? Yes or no? Audio, video is perfect. Break is over. So can we start? I think so. That is not visible. Can we start now? Kindly comment in the audio and video is proper. Audio, video is proper. Can we start now? So next is section 36. Okay. Okay. Deals with Directorate of Enforcement. Okay, perfect, Priya. Thank you, Priya. So section 36 deals with Directorate of Enforcement. The central government shall establish a Directorate of Enforcement with a director and such other officer who we can call as an officer of enforcement for the purpose of this act. Now, all the section 4 to 5 section, they are purely theoretical section concepts. The central government may authorize the Directorate of Enforcement, Additional Directorate of Enforcement, Special Director of Enforcement, and Deputy Director of Enforcement to appoint officers of enforcement below the rank of Assistant AD, right? ADE, Assistant Directorate of Enforcement. Purely theoretical concept, section 36. Section 37 is quite a smaller section, power of search and seizure. The Directorate of Enforcement and other officers of enforcement not below the rank of Assistant Director shall take up the investigation and contravention referred to in section 13. Presentation as to the document in certain cases, section 39. Where any document is produced, furnished by any person or been seized from the custody or control of any person, has been received from any place outside India. If you have received any document from outside India, in the course of investigation of any contravention under this act, such a document is tendered in any proceeding under this act as a evidence. Presume that signature below belongs to the particular person and admit the document as a evidence, irrespective of the fact that it is unstamped, right? Irrespective of the fact that is unstamped. So the section 39 talks about the document part. If he received any document, that document will be taken as a evidence part, right? So section 36 ED part, section 37 search and seizure part, and section 39 deals with the evidence part, document part. Okay. So section 36 theoretical part from study mat part. The central government shall establish a Directorate of Enforcement with a director and such other officer or class of officer as it thinks fit, who shall be called officers of enforcement for the purpose of this act. The central government may authorize the Director of Enforcement, Additional Director of Enforcement, Special Director, Deputy Director to appoint officers of enforcement below the rank of Assistant Directorate of Enforcement. Subject to such conditions and limitations as the central government may impose, an officer of enforcement may exercise the power and discharge the functions as prescribed in this act. Section 37 talks about the search and seizure, and section 38 empowering other officers. Again, theoretical part. The central government may by order submit to such condition limitation as it thinks fit to impose, authorize any officer of custom, any central excise officer, police officer, or any officer of the central government, state government, or to exercise such power or discharge such of the duties of Director of Enforcement or any other officer of enforcement under this act as may be stated in the order. The officer referred to in subsection 1 shall exercise the same power as income tax officers are exercising during the search and seizure. Okay. Section 39, miscellaneous provision, where any document is produced or furnished or received from out, this is furnished, this is received from any place outside India, presume that the same is not contrary is proof, the signature of every other part of such document which purports to be handwriting of a particular person, or which the court may reasonably assume to have been signed by, is the person handwriting in the case of document executed, attested that it was executed or attested by the person by whom it purports to have been so executed or attested. Admit the document in evidence notwithstanding that it is not duly stamped, means unstamped document can be accepted as a evidence, right? So there's a Stamp Act 1899 which talks about an unstamped document cannot be accepted as a evidence, but that provision provides the power. If the document is unstamped, then too you can present as a document. In a case falling under clause 1, also presume unless the contrary is proved the truth of the content of such document part, right? So this is the concept which we need to remember that. Section 14, suspension of operation of this act. If the central government is satisfied that the circumstances have arisen rendering it to necessary that any permission granted or restriction imposed under this act shall cease to be granted or imposed or considered necessary, expending to do in the public interest, so central government can suspend or relax to such extent either indefinitely or for such period the operation of all or some provision of this act. So government has the power that they can suspend a whole provision or some part of the provision for such time. Where the operation of any provision of the act under subsection 1 been suspended or relaxed indefinitely, such suspension relaxation may at any time while this act remains in force be removed by the central government by notification. And whatever suspension, whatever changes you are doing, that should be approved within both the houses of parliament within 30 days. Whether the parliament is in session or not. Same provision as was applicable for approval part. Power of central government to give directions. Okay, section 41 is simple. And whenever there is a confirmation by a company, always there will be a 2 paragraph. First point deal with the confirmation by the company, and second point deal with the every person who at the time the confirmation was committed was in charge responsible to the company for guilty be liable for the proceed against and punished accordingly. Or if it is proved that the confirmation have been taken place with the consent or neglect of any director, manager, secretary, they are also liable. Death or insolvency in certain cases, any right, obligation, liability, proceeding, appeal arising in relation to provision of section 13 shall not abate by reason of death, insolvency of the person liable under the section. Upon such death or insolvency, such right or obligation, such shall devolve on the legal representative of such person. Provided that the legal representative of the deceased shall be liable only to the extent of the inheritance or estate of the deceased. This is the basic funda, right? For example, there is Mr. A. Mr. A is the person to whom the FEMA Act applies, and that Mr. A expired due to some reasons. Now, Mr. B is the son of Mr. A. In that case, Mr. B liability will be restricted to the amount of assets which he received from Mr. A, right? Provided that LR means B, shall be liable only to the extent of the inheritance or estate of the deceased. This is the basic principle which applies to succession. Bar legal proceeding, no suit proceeding, other legal proceedings shall lie against the central government perfectly, or the Reserve Bank of India, or any officer of that government, or RBI, or the person exercising, because it is assumed that they are discharging their power in good faith by default. This is the concept. Correct. So with this we completed the concept of FEMA. Now, okay, there is a one section more, compounding of offenses. Section 15 deals with the compounding of offenses, right? Now, what is the meaning of compounding offenses? If any person has committed any offense, so he can pay extra fine to the authority, to the government, and that offense will get compounded. He will not liable for the prosecution, imprisonment, or something like that. But compounding authority, person authorized by central government under section 15, that is classes of officers of the Enforcement Directorate or classes of officers of RBI can act as a compounding officer. Okay. So classes of officers of ED stands for Enforcement Directorate, or the classes of officers of the RBI, they will act as a compounding officer. According to section 15, period of compounding of an offense, any contravention under section 13 may be compounded within 180 days if the application is filed to ED or such other officer as may be appointed by the RBI. In case of compounding, no proceeding shall be intimated or continued against the person committing the contravention under this section in respect of the contravention so compounding, right? So this is the basic of section 15. It is called compounding of offenses. So compounding of offenses deals with the, like if a person is contravened any provision of section 30, then that can be compounded, that can be remedied, that remedy can be provided by paying the extra fine to the respective authority. I think so. Now this is clear. That's all about the FEMA part. Now, three topics we have remaining. First is import of goods. Second is ODI, overseas direct investment, and third is ECB, external commercial borrowing part. So that all will complete our syllabus of CA finally. Okay, so now we will proceed towards import of goods and services. Can we proceed towards the import of goods and services? Yes or no? Kindly comment in the chat box whether we can start the import of goods and services. Yes or no? Whether we can start the import of goods and services, yes or no? Whether, okay, we can start the import of goods and services, yes or no? I think it's perfect. Can we proceed towards import of goods and services? I think so. Audio, video, everything is perfect, and connection is also good. So what is compounding? Compounding means government has prescribed some authorities to whom power is exercised. If any person has contravened the provision of Section 13, Section 13 prescribes the penalty part. If you can remember, there is a penalty of 10,000 for the first offences. If any person has committed the contravention of Act, provision, rules, regulation, notification, then there is a penalty prescribed under Section 13, that is 10,000, 2,000 rupees per day default, right? And if that person goes towards the respective authorities within 180 days from the date of contravention, then that respective authorities, that is enforcement of Directorate or RBI officer, can rectify that default. When the defaulter person pays some extra fine, means case will not start, suit will not start, nothing will start. Okay, Vinod. Okay, so now we are going to start the import of goods and services concept, right? Now, what is import of goods and services? Same as export of goods and services. Importing means we are importing some goods and services from a place outside India. Try to relate that import of goods and services with export of goods and services, right? Let's start. We will take these topics in a very slow manner, right? Introduction, first point. Import of goods and services into India is allowed in Section 5. Import of goods and services allowed in Section 5. Export of goods and services allowed in Section 7 of FEMA 1999, read with Foreign Exchange Management Current Account Transaction Rules 2000. Import trade is regulated by, there is an authority called DGFT, Director General of Foreign Trade, under the Ministry of Commerce and Industry, Department of Commerce, Government of India. So from this paragraph, two things are important. First, Section 5. Section 5 deals with the current account transaction. So with this current account transaction, import of goods also deals with Section 5, right? And there is an authority, DGFT, Director General of Foreign Trade. Udit got a call from my office. Okay. Right. So this is first point, import of goods and services, right? You need to remember two things. Section 5 and authority is DGFT, Director General of Foreign Trade, who is the authority for governing this import of goods and services. Okay. For importing, we need foreign exchange. And whenever there is a foreign exchange, there is a Section 10, means we are talking for authorized dealer, category 1. Banks should ensure that import into India are in conformity with the FTP, Foreign Trade Policy. Right? We need to adhere, we need to accept the provision of Foreign Trade Policy also. Enforce and FEM, Foreign Trade Policy, generally that policy reveals the 5 years time period, right? They prepare the 5 years time period. Foreign Exchange Management Current Account Transaction Rules means we need to provide FTP, we need to provide Current Account Transaction Rules 1999 along with RBI direction. Means these are the regulation part with respect to import of goods and services. Okay, so from introduction part, 5 things important, or in fact 2 things are important. First is Section 5 will govern. There is an authority called DGFT who is going to regulate that Section 5 import of goods and services concept. Now you need to comply for the regulation part. Authorized dealer, Section 10 will come. So authorized dealer category 1 is there. That particular bank or authorized person will, that whatever you are importing, that should be conformity with the Foreign Trade Policy, Current Account Transaction Rules, RBI directions. I think so. First point, introduction is complete. Along with the charts part, we will see this theory part also, so you will get the overall idea. Okay, so import of goods and services into India is allowed as per Section 5 of FEMA. Okay. With the current account transaction rules, there was no specific notification for import. It is regulated by Master Circular number. Okay, that is not relevant for you. Okay. Import trade is regulated by DGFT, Director General of Foreign Trade, under the Ministry of Trade and Commerce, Industry Department of Commerce, Government of India. Authorized dealer category 1, bank should ensure that they need to comply the FTP provision, foreign trade policy, current account transaction rules, or RBI directions. Okay, so this is the introduction part. Second, general guidelines for import. Rules and regulations are to be followed by authorized dealer. Who is going to follow rules? Authorized dealer. While overtaking import payment transaction on behalf of client, obviously, whenever we need to make any payment in import, whenever we need to make any payment to outside India, we need to take the help of authorized person. So that law cast responsibility over the authorized person, that you need to remember, you are going to make the payment for such import, then you need to remember the rules. Right, authorized person, the rules and regulations to be followed by the AP. Authorized dealer must particularly adhere to the KYC guidelines issued by the RBI KYC guidelines. Accordingly, you need to follow. Remittance for import payment. Authorized dealer may allow remittance for making payment for import after ensuring that whatever legal requirements are there, whatever legal requirement is prescribed by the RBI or the Government of India or the FTP regulations or current account transaction section 5 that needs to be complied, are made available by importer, and remittance is for the bona fide. Bona fide means good faith. Bona fide trade transaction as per the law. You need to comply that particular whatever remittance you are doing for import payment, that should be bona fide. Importer has provided all the details. Then only authorized dealer will release the payment part. So second point is this. General guideline for import, general guideline regulation, rules and regulations to be followed by the AD from the foreign exchange angle while undertaking import payment transaction on behalf of their client as given in para 2 of the master direction. Where any specific regulation do not exist, AD may be governed by normal trade practices, and you need to comply the KYC regulations also. Second point, AD may allow remittance for making payment for import into India after ensuring that all the requisite details are made available by the importer, and the remittance for the bona fide means good faith. Now, so this is the first chart of import of goods and services. I think so. First chart is clear. First chart is clear. I think 5 to 6 charts are there for import of goods and services. First chart is clear or not? Of import and goods and services. First chart is clear or not? We discussed 2 points, introduction and general guidelines for import. Now the important one. And third point deals with obligation of purchaser of foreign exchange. What are the obligations of purchaser of foreign exchange? It shall be utilized for the purpose mentioned in the declaration. Achha. Now, who is the purchaser of foreign exchange? Means we, Indian person. Or we can say Indian importer. Right? That Indian importer will purchase by exchange of rupees the foreign exchange, then he will remit to the other person. So what are the obligations of Indian importer? It shall be utilized for the purpose mentioned the declaration made by him to authorized dealer or for any other purpose which is permissible under the Act, rules, regulations. So law has clearly specified that it is the duty of the Indian importer, right? That whatever purpose you declare in the document that you are you require $1 lakh, $2 lakh for the purpose of payment of any services kind of thing, revenue nature services kind of thing, which falls under current account transaction. So that needs to be complied. First point. AD should ensure that importer furnishes evidence of import as in ID IPMS, that is called Import Data Processing and Monitoring System. There is a system. Postal appraisal form or custom assessment certificate. So you need to provide anything so that we can assess that whatever you are demanding, that is as per the requirement, as per the department part, and satisfy himself that the goods equivalent to the value of remittance have been imported. मतलब ऐसा ना हो $1,00,000 लिया आरबीआई से और हमने $20,000 का कोई सामान मंगाया, 80,000 का उड़ा दिया. No, that is not allowed. AD should ensure that all import remittance outstanding on the notified day of IDPMS are uploaded in particular system document. A person resident in India may make payment for the import of goods in Forex. Obviously, Forex means foreign exchange through. You can make a payment through international card held by him in rupees from international credit card, debit card through credit debit card, servicing banking in India against the charge slip signed by the importer, or as prescribed by RBI from time to time, provided that import is in conformity with the FTP. For example, you are importing something, but that is restricted under the foreign trade policy, then you are not supposed to import that thing. A PRI means importer, right? Indian importer. Also make payment in rupees for meeting expenses on account of boarding, lodging, services related thereto, or travel to or from within India of PRY who is on visit to India. Maybe the person resident in India who is going to export you some machinery, he wants to inspect that whether you are a party of particular nature or not, you are a competent person or not. So for the expenses you need to meet out, right? You need to make an arrangement in particular dhaba for the person for stay and for fooding and lodging, so that should be taken care. By means of cross-check, draft as consideration for purchase of goods and silver imported. A company or a resident in India may make payment in rupees to its non-whole-time director who is resident outside India and who is on visit to India for company work, or is entitled to payment of sitting fees, commission, remuneration, travel expenses to or from within India as per the company memorandum of association, article of association, any agreement, any resolution, shareholder resolution or board resolution. So that all needs to be taken care, right? I think so. Third point, obligation of purchaser is clear. Now read with the theory part. Obligation of purchaser of foreign exchange means we are talking for Indian importer. Following are the obligations to be complied by the purchaser. First, utilization of acquired foreign exchange means for what purposes you took that foreign exchange, you need to utilize for that purpose only or any other purpose as permitted by RBI or under the FEMA Act. Means you cannot use for the purpose that is prohibited, right? In terms of section 10(6) means authorized dealer definition. Any person acquiring foreign exchange is permitted to use it for either purpose mentioned in the declaration made by him to authorized person or for any other purpose for which the acquisition of foreign exchange is permissible under the said Act rules regulations framed thereunder. Evidence of import where a foreign exchange acquired has been utilized for import of goods into India. The authorized dealer should ensure that importer furnishes evidence of import as in IDPMS portal appraisal form, custom assessment certificate, and satisfy that goods equivalent to that have been imported. AD should ensure that all the import remittance outstanding on the notified date that needs to be uploaded. Mode of payment. A person resident in India, Indian importer, make payment via international card or credit card, debit card, or facility provided by the respective banks or as prescribed by the Reserve Bank of India from time to time. Whatever payment you are doing, whatever thing you are importing, that should be conformity with the FTP policy. In essence, payment has to be made through banking channel. Other modes, Other modes means for that a person resident in India may also make payment in Indian rupees to a meeting of the expenses of boarding, lodging, services related to or travel from or within India of a person resident outside India who is on visit to India by means of cross-check draft. A company or a resident in India may make payment in rupees to its non-whole-time director who is a resident outside India and who is visit to India for a company work is entitled for payment of sitting fees, right? Sitting fees that is allowed as per the prescribed provisions of MOA and AOA. So with this, we completed the 3 points of import of goods and services. Okay, so is there any problem in import of goods and services? First 3 points. If you have any problem, you can ask your doubts. If you have any problem, you can ask your doubts. If you have any problem, you can ask your doubt. First, second, third. Okay, move further. Time limit for settlement of import payment. For normal imports, for deferred payment arrangement, remittance against import should be completed not later than 6 months from the date of shipment. Means you need to make the payment within 6 months from the date of shipment. Means when you actually imported the goods into India. Except in cases where amount are withheld towards guarantee of performance. Means maybe you imported some machinery and you have that agreement, with the exporter of the other country that if that yes, you can mention your doubt. I will answer, no issue that. Okay. So you imported some machinery from outside India, from say for example Japan. You imported some machinery, but you will make a remaining. You made 80% of the payment. For remaining 20%, payment depend upon the performance or efficiency of the machinery. So okay, you can withhold that amount. It is not necessary for payment within 6 months. AD may permit delayed settlement of import dues due to disputes, financial difficulty, etc. For deferred payment system arrangement, DPA, including supplier or buyer's credit, up to 5 years are treated as trade credit, for which guidelines mentioned in the circular for ECB and credit credits may be followed. Okay, so up to 5 years. 5 years, agar if that credit is allowed, so you can make payment within that time period. However, interest, if any, on such delayed payment or usance bill. Usance bill means bill of exchange that allows drawee to have period of credit on term or overdue interest is payable only for a period up to 3 years from the date of shipment as prescribed from time to time. Means interest for delayed payment restricted by the import of services guidelines up to 3 years. Means we will provide foreign exchange for the payment of interest on delayed payment for maximum up to 3 years. So that is point number 4. So that is point number 4. Okay. Time limit for settlement of import payment. Time limit for normal imports. In terms of extent regulations, remittance against import should be completed not later than 6 months from the date of shipment, except in cases where amount are withheld towards guarantee of performance, etc. AD may permit settlement of import dues delayed due to disputes, financial difficulty, etc. However, interest, if any, on such delayed payment, usance bill, bill of exchange, maximum you can pay up to 3 years. That is, more than that amount is not allowed, right? Time limit for deferred payment arrangement, maximum up to 5 years. Deferred payment arrangement, including suppliers paid buyers get up to 5 years, are treated as a trade credits for which the procedural guidelines are laid down by the Master Circular for ECB. Okay, extension of time. Limit of extension. AD can consider granting extension of time for settlement of import dues up to the period of 6 months at a time, maximum up to a period of 3 years, means 6 months plus 6 months plus 6 months. You can take extension till 5 times. Sorry, 6 times, right? Irrespective of the invoice value for delay on account of dispute about the quantity, quality, non-fulfillment of terms and conditions. Financial difficulty cases where the importer has filed suit against the seller. So the settlement time period can be 6 months, maximum up to 3 years, 6 months at one time. So you can take 6 months plus 6 months plus 6 months, 6 plus 6 plus 6, no issues at all. But at a stretch, एक बार में maximum 6 months का. In case where sector specific guidelines have been issued by the RBI for extension of time, that is rough cut polished diamond, the same will be applicable. Circumstances while granting extension of time, AD must ensure that import transaction covered by invoices are not under investigation, okay, by enforcement director or CBI, right? Investigation should not be done by this. While considering extension beyond 1 year from date of remittance, the total outstanding of importer does not exceed 1 million USD, 10 lakh USD, or 10% of the average import remittance during the 2 preceding financial year, whichever is lower. This is the maximum remaining amount unpaid. Where extension of time has been granted by AD, the date up to which extension has been granted may be indicated in remark column. Note: cases not covered by above instructions beyond the above limit may be referred to concerned regional office of RBI. The above extension period shall be reported in the IDPMS as per the message bill of entry extension. And the date up to which extension is granted will be indicated in the extension date column. So fifth point, talking about the extension of time. Extension, we will provide the extension 6 months at one time up to maximum 3 years. Extension will not be provided if the scrutiny is done by the ED or CBI. Some inquiries going on. Extension, considering extension beyond 1 year from the date of remittance, means extension can be provided in parts. 1 year up to without any tension. Beyond 1 year, the maximum amount remaining will be 10 lakh USD or 1% of the 10% of the average import remittance in the preceding 2 financial years. Point number 5, extension of time. Limit of extension, ED category 1. Banks can consider a granting extension of time for settlement of import due up to a period of 6 months at one time, maximum up to a period of 3 years. Irrespective of the invoice value for delay on account of dispute between the quantity, dispute about the quantity, quality, non-fulfillment condition, etc., etc., etc. In case where specific sector guidelines are issued by RBI, you need to follow that. Diamonds applicable. Circumstances. AD must ensure that, authorized dealer must ensure that the transaction is not covered by the invoices which are under investigation, then it is not allowed. While considering extension beyond 1 year from the date of shipment, the total amount remaining unpaid to the foreign exporter is a maximum 10 lakh USD or 10% of the inward remittance in the previous 2 financial year, whichever is lower. where extension of time have been granted by AD. The date up to which extension has been granted may be indicated in the remark column. In exceptional cases not covered by the above instructions or beyond the above limit may be referred to the concerned regional office of the Reserve Bank of India. Noting of the extension, the above extension period shall be reported in IDPMS as per message bill of entry extension, and the date up to which extension is granted will be indicated as extension date column. So that is point number 5. I think so. We have covered half topic of important goods and services. I think so till point number 5. If you have any doubt, you can ask your doubt. In point number 5, if you have any doubt, you can ask your doubt. Till point number 5, if you have any doubt in this topic, let me know. Okay, no problem. Okay, so point number 6 is there. Before moving towards the point number 6, okay. Now, point number 6, import of foreign exchange or Indian rupees. Except as otherwise provided in the regulation, no person shall, without general or special permission of RBI, okay, import or bring into India any foreign currency. It is governed by the FEMA 1999 and Regulation 2000, right? So what they have mentioned, you need to take the approval, right? RBI may allow a person to bring into India currency notes of Government of India subject to RBI terms and conditions. So point number 6 is not at all such technical part. Point number 7, import of foreign exchange into India. A person may send into India, means foreigner will enter. A person may send into India without limit foreign in any form other than currency notes, banknote, traveler check, bringing into India from a place outside India without limit for other than the unissued note, subject to condition that such person makes a declaration to custom authority on arrival in India in airport in CDF, currency declaration form, provided that it shall not be necessary to make such a declaration if aggregate value of foreign exchange in form of currency notes, bank note, traveler check at one time exceeds $10,000, there is no problem of declaration. Equivalent or the aggregate value of foreign currency notes, cash portion alone brought by such person at one time does not exceed $5,000 or its equivalent. Point number 8, import of Indian currency and currency notes. Any person resident in India who has gone out of India on a temporary visit may bring into India at his return from any other place outside India except Nepal, Bhutan ko chhodkar. There is no transaction with Nepal and Bhutan. Currency notes of Government of India, RBI notes up to the amount not exceeding 25,000. So there is no restriction till 25,000 rupees. A person may bring into India from Nepal and Bhutan currency notes of Government of India not more than in a any amount in denomination up to 100, right? So there is no restriction from a person bringing any amount from Nepal and Bhutan in denomination of 100 rupees, right? Means you cannot bring in the denomination of 500. Suppose if you can just calculate, like for example, somebody is bringing 10 lakh rupees from Nepal and Bhutan, then in what container he need to retain that amount? Government restriction is quite good, yeah. Issuance of guarantee by an authorized dealer. AD may give a guarantee in respect of any debt, obligation, or other liability incurred by a person resident, means Indian importer, and owned to a person resident outside India as an importer in respect of import on deferred payment system as per the RBI approval, right? RBI approval for import on such terms. And AD may give guarantee, letter of credit, letter of comfort in respect of debt. So they will provide a guarantee to the outside exporter on behalf of Indian importer. Incurred by PROI, owned by PROI, overseas supplier of goods, banks, or financial institution for import of goods as permitted under the FTP or rules. An AD may, in the ordinary course of business, gives a guarantee in favor of okay, so they will provide a guarantee, but they also need some kind of security. On behalf of, the reason is why this required, because we actually don't know the Indian exporter, sorry, outside exporter. So authorized dealer will act like, for example, there is an offshore banking unit or there is a other bank of Indian bank. So they have a trust over them. They don't have a trust import exporter. So they will provide a link kind of thing. Who is a service importer subject to such terms and conditions as RBI may impose? Authorized dealer may, subject to a direction issued by the RBI, permit a person resident in India to issue corporate guarantee in favor of overseas lessor for financing import through operating lease affected in conformity with FTP regulation and guidelines. Limit of providing guarantee, right? So they have mentioned the limit. Service importer, where a service importer is other than a public sector company or a department, government of India or state government. No guarantee for an amount exceeding USD 5 lakh or equally shall be issued, maximum 5 lakh rupees. Where the service exporter is the government, PSU, no department or undertaking of government of India, no guarantee for an amount exceeding $1 lakh or its equivalent shall be issued without prior approval of Ministry of Finance, Government of India. So this is the point number 9. Correct. So importer of goods and services, point 6 is the pure theoretical part. Except as otherwise provided in the regulation, no person shall, without the general special purpose, bring any foreign exchange into India. Import is allowed as per the rules regulation, or RBI may allow any person. Import of foreign exchange into India, a person may send into India without limit foreign exchange in any form other than Indian currency form, other than currency notes, bank note, traveler check, bringing into India from a place outside India without limit. Foreign exchange other than unissued notes subject to condition that such person makes on arrival. You need to make a declaration, CDF, custom declaration form. Provided further that it shall not be necessary to make such a declaration where the aggregate amount you are bringing is $10,000 and in Indian currency, cash portion is $5,000. Import of Indian currency and currency notes. Any person visiting other than from Nepal and Bhutan, in that case, 25,000 is the maximum limit, rupees limit, right? And from other than Nepal and Bhutan, there is no limit, but the denomination should be up to 100 rupees. Means you can bring 10 rupees notes, 5 rupees notes, no issue at all. Issuance of guarantee by authorized dealer. An authorized dealer may bring a guarantee in form of debt, obligation, or other person for the Indian importer in respect of import on deferred payment system, because deferred payment system is up to 5 years. With the approval of Reserve Bank of India for import on such terms, an authorized dealer may give guarantee, letter of undertaking, letter of comfort in respect of any debt, obligation, other liability incurred by person resident in India and owned to a person resident outside India for import of goods as permitted under the FTP guidelines. An authorized dealer may, in the ordinary course of business, gives a guarantee in favor of a non-resident service provider on behalf of a resident customer who is of service importer, subject to such terms and conditions specified by the RBI. Limit of providing guarantee, and this is if other than PSU $5 lakh, PSU is $1 lakh. So this is the overall concept of an authorized dealer may, subject to the direction issued by the Reserve Bank of India in this behalf, permit a PRIA to issue corporate guarantee in favor of overseas. Right. So that is overall concept of import of goods and services. So is there any doubt in import of goods and services? Examiner will ask a simple short note from this. Examiner will ask short note from this only. If you have any doubt, you can let me know. If you have any doubt, you can let me know for this part. Okay. So last topic is ODI. ODI stands for Overseas Direct Investment. Okay, no doubt. So overseas direct investment, we have 6 chart, and ODI is by resident in overseas. We are going to make an investment by a resident individual. Overseas means outside India. Right? So overseas direct investment, ODI, or financial commitment in joint venture. This is a kind of investment, right? In form of guarantee. Joint venture or WOS means wholly owned subsidiaries have been recognized as important avenues for promoting global business by Indian entrepreneurs, and JVs are perceived as a medium of economic and business cooperation between India and other countries. So joint venture, wholly owned subsidiaries means Indian corporates are going to invest outside India. Section 6, that is called capital account transaction, provides power to RBI to specify in consultation with GOI the classes of permissible capital account transaction and permissible limits. RBI issued foreign transfer or issue of any foreign security regulation. This seeks to regulate acquisition or transfer of foreign security by a PRI. PRI means person resident in India. That is, investment by Indian entities in overseas joint venture, wholly owned subsidy, are also investment by PRI in shares and securities issued outside India. Kumar Udit, I think you can do one thing. You can just recall the question number 12 of RTP May 2020 by import of goods and services. Then maybe you will find that it is current account transaction. I will also see the doubt from RTP itself. Now, important definition. What do you mean by direct investment outside India? Means investment either under automatic route or approval route. Now, what is automatic route? So government will prescribe some condition. You can fulfill that condition. So that is automatic route. Approval route, if a person fails to fulfill any of the condition, then they can make an application to the central government and central government will provide approval. So it is called approval route. Automatic route, approval route by way of contribution to capital, subscription to MOA of a foreign entity. Perfectly. You can directly subscribe the memorandum of, you can directly subscribe the capital of the company. You can directly make an investment. Or purchase of existing shares of a foreign entity, either by market purchase, you can purchase from market, or private placement, they will make a private placement to yourself, or through stock exchange signifying a long-term interest in foreign entity, either as a joint venture and a wholly owned subsidiary. Perfectly right and very simple. This is for new company, and this is for existing company. So new company, you can be a subscriber of the company, you can capital contribute. For existing company, you can purchase from open market, from stock market, from share purchase agreement. However, it does not include portfolio investment, that is investment in the form of group of assets including transaction in equity, debt, bond, debenture, bank note. No, we are not here for trading income. We are making the investment for business purpose. Financial commitment means the amount of direct investment by way of contribution to equity, loan, and 100% of the amount of guarantee or 50% of performance guarantee issued by Indian party to on behalf of an overseas joint venture or wholly owned subsidiary company, that we can call as a financial commitment. Okay, modes of ODI: automatic route by fulfillment of condition. Indian party has been permitted to make investment, undertake financial commitment in overseas joint venture as per the ceiling limit prescribed by RBI. It has been decided that any financial commitment exceeding $1 billion in a financial year would require prior approval of Reserve Bank of India. If you need to invest more than 1 million, right, you need to apply it, you need to take the approval of RBI. Even though the total financial commitment of Indian party is within the ceiling limit order prescribed under automatic route, that is within 400% of the net worth, that is paid up share capital, free reserve as per the, but the investment size is more than 1 billion, you need to take the approval route irrespective of the fact whether this is under the limit of 400% of the net worth, which is eligible for automatic route. Limit permissible. The total financial commitment of Indian party in all. So the most important thing is, just a minute. Extension of time guarantee. Okay. The most important word is in all. In all joint venture wholly owned shall comprise of the following. Means you are not, this limit is not prescribed as per each exporter country or each foreign entity. That is compared from the person perspective, that I am going to invest outside India. So what is the exactly limit of this one? So first is 100% of the amount of equity shares or compulsory convertible preference shares. Second limit is 100% of amount of other preference share. Third is 100% of amount of loan. Fourth is 100% of amount of guarantee issued by Indian party other than the performance guarantee. 100% of the amount of bank guarantee issued by resident bank on behalf of joint venture wholly owned subsidiary of Indian party, provided the bank guarantee is backed by the counter guarantee collateral by Indian party, or 50% of the amount of performance guarantee issued by Indian party, provided that if outflow on account of invocation of performance guarantee. So guarantee is 50%, rest everything is 100%. Guarantee is 50%, right? Performance guarantee provided is 50%. So what are the requirements for that investment part? Criteria for ODI under automatic route is as under. Indian party can prescribe up to the prescribed limit of its net worth in joint venture wholly owned for a bona fide activity. You are not supposed to make an investment for smuggling purpose, right? For bona fide activity, that is permissible. Permitted as per the law of host country, country in which foreign entity receiving direct investment from an Indian party is, but means foreign country. Host country means foreign country. Limit will not be applicable where investment is made out of EFC account of Indian party or out of fund raised by ADR GDR. Indian party is not on RBI exporter means defaulter list, that is not permissible, means Vijay Mallya type. Indian party route all the transactions relating to investment in JV or WOS through only one branch of an AD to be designated by Indian party. Now, what is the process? Indian party should approach an authorized dealer with an application from ODI and prescribe enclosures documents for affecting the remittance towards such investment. So Indian party need to approach to authorized dealer. Investment in joint venture wholly owned subsidiaries through SPV, special purpose vehicle, means they will provide a framework for investing, are also permitted under automatic route. Indian party should not appear in defaulter caution list. This is the most important point, that you Indian party should not be in the RBI caution list. Approval route is different. Automatic route is different. Approval route for direct investment or foreign contribution outside India. So prior approval of RBI approval would be required in all other cases of ODI FCI. RBI would also consider the following points while providing the approval. First, prima facie viability of the, what is the viability of the joint venture wholly owned subsidiary to whom you are going to invest? Contribution to external trade and other benefit which will accrue to India. Okay, from your investment, what type of benefit that India will receive? Financial position and business track record of Indian entity, foreign entity, both the records they will check. Expertise and experience of Indian party in the same or related line of activity of. So what is your experience in the respective file? Therefore, under approval route, prior approval of RBI is compulsory required, for which a specific application in form ODI is to be done through authorized dealer category 1. Till chart, if you have any doubt, you can ask for ODI part. Overseas direct investment by resident individuals means I can invest. Resident individual. A resident individual may make ODI in equity shares or compulsory convertible preference shares of joint venture wholly owned subsidiaries outside India. Limit of this ODI shall be within the overall limit prescribed by RBI order. Provision of LRS scheme, liberalized remittance scheme, and liberalized remittance scheme permits $2.5 lakh per financial year. Prohibition on ODI. Indian parties are prohibited from making investment in foreign entity engaged in real estate. Okay, so you are not supposed to make investment in real estates. That is buying, selling of real estates or trading in TDR, but does not include department of townships, construction, residential, commercial premises, road or bridges, or banking business without the approval of RBI. That is permissible. An overseas entity having direct indirect equity participation by an Indian party shall not offer financial product linked to Indian rupees without specific means you will not provide a financial product. Example, rupee exchange rates, stock indices linked to Indian market, etc. General permission. General permission has been granted to person resident in India for purchase or acquisition of security in following manner. First, general permission. Resident foreign currency account, you can invest, individual can invest. As a bonus shares on existing holders, that is also allowed, bonus shares that they are providing. When not permanently resident in India out of their foreign currency resources outside India, general permission is also available to sell the shares so purchase or acquired, right? So this is all concept which provides the general permission to the person concerned. So that's all about the ODI part. And this is the theoretical part. Udit, you need to search, right? ODI, so that is joint venture, wholly owned subsidiaries. We already check out this one. Relevant provision is FEMA. FEMA allows for this one. Now, ODI means either automatic route, approval route by way of contribution to capital, fresh company or existing company. In the case of existing company, you can take the shares, but does not include the portfolio investment, because the reason why we are investing in portfolio investment is to earn from trading side, trading of shares. But that ODI we are talking for the company side. Financial commitment is direct investment by way of equity, loan, 100% in guarantee and 50% in case of performance guarantee. RBI permission. RBI is permitted total financial commitment of up to 400% of net worth. Right? This is allowed. Net worth is paid up share capital, free reserve. Joint venture is this. Wholly owned subsidiary is this. Indian party means Indian company, body corporate. Host country means foreign company, foreign country. Mode of direct investment outside India. Automatic route. Regulation 6. Indian party have been permitted to make investment, undertake financial commitment in overseas joint venture, wholly owned subsidiary, as per the ceiling prescribed by RBI. But if you are going to invest, if we are going to invest more than 1 billion Indian companies, then irrespective of this fact that it is within the limit of 400% of net worth, you need to take the RBI approval. This is important point. Limit permissible 100%, 100%, 100%, 100%, except one thing, there is a 50% that belongs with the performance guarantee. Requirement for investment, bona fide activity. Indian party is not on the RBI caution list, defaulter list. The Indian party routes all the transaction relating to investment from only one branch of authorized dealer process. The Indian party should approach an authorized dealer with an application in form ODI, prescribe enclosures, documents. Approval routes for direct investment or financial commitment outside India. So approval route, prior approval of Reserve Bank would be required in all the cases of direct investment or financial commitment abroad. RBI would inter alia take into account the following factors while considering the application. Prima facie viability of outside project, financial position of both the company, experience of your company, prohibition on direct investment abroad by Indian company, real estate not allowed, trading in TDR not allowed. This is mentioned. Right? Your foreign company will not provide anything rupee linked instrument, Indian stock indices. Method of funding, investment or financial commitment in an overseas. Investment or financial commitment in an overseas joint venture, WO, wholly owned subsidiary may be funded out of one or more of the following sources. Drawal of foreign exchange from an AD bank in India, capitalization of exports, swap of share, valuation as maintained, proceeds of ECB, FCCB. So that is allowed, and general permission is allowed from RFC account, bonus shares, right? Not permanently resident in India out of this one. And general permission is also available to sell the shares, so purchase or acquired, right? So that's all about today's discussion, which deals with. So now we completed the FEMA part. We completed the import of goods and services. We completed the ODI. Now, except one thing, that is called external commercial borrowing, we will discuss on our last lecture of our FEMA on 21st of February. If you have any problem, you can put your doubts in the ICAI portal. Right? I think so. Law via charts is quite easy. You can easily recall the provision, whatever provision is there with the charts only, right? So if you have any doubt, if you want to praise the charts, you can, no issues at all. Okay, thanks a lot. Thanks a lot for today. Patience.